number 64, Garcia versus New York City Department of Health and Mental Hygiene.
Good afternoon. May it please the court, I'm Richard Deering for the city. I'd like to reserve 2 minutes for rebuttal if I could.
Hi, sir.
The Board of Health's flu vaccine daycare rule here is of a piece with a long history of vaccination requirements running all the way back to 1866. All of them.
Is the flu vaccine required in any other body of law?
It is required in New York State or outside of New York State?
Both.
I'm not aware of its being required in New York State otherwise. I mean, there is a state reg for healthcare workers that say they either must be vaccinated or must wear a mask if they choose to be unvaccinated.
So is that alone an indication that the department was engaged in policy making?
No, I don't think so, because the deeper practice of mandatory vaccine rules is well established, not just in New York State, but across the country. And the Board of Health was, in fact, a leader in those rules. It has enacted them, as I said, running all the way back to 1866.
But the state has chosen not to do it. So if they've chosen not to do it, how are you able to decide that you're going to impose this requirement?
That's the essence of power of the existence of authority in New York City to adopt.
No, I'm sorry, but the question that I'm trying to get to is if the state has made a decision that mandating vaccines is not the appropriate way to respond to a health concern, can the city decide otherwise?
Well, the state has made a decision in general that mandating vaccines is an appropriate step. This is similar in a sense to the point made in Acevedo that strategy.
With respect to the flu vaccine.
With respect to flu, I think the state of affairs is that the state has not yet adopted a mandatory flu vaccine.
But isn't that true of almost every vaccination that the state has ultimately adopted, that the city adopted it first?
Precisely. The city was in this space long before the state ever was. The state modeled what is now Public Health Law 2164 on the city's prior efforts, including the definition of daycare that was included in that statute. The legislative history referred specifically to the efforts of the Board of Health in that regard. The point being that the Board of Health has led in this area for over a century.
So the state could have expressly preempted the city, correct?
Yes, Your Honor.
And it could have impliedly also, right?
I don't think in this instance.
No, I mean, just as a theoretical legal matter.
In
Yes,
theory,
there is a doctrine
yes,
of
Your
implied
Honor.
preemption, and they could have, and there's something that would be implied preemption that is short of express. So what more here than what the state did would have been necessary to get to implied preemption without getting to express preemption?
Well, first, an observation, sort of a follow-up on the interjection I had a minute ago, which is that this case comes in a little bit of a different posture, which makes preemption not the right framework for looking at this. And the reason is that the state legislature, the board's history of acting in this area did not occur in a vacuum. It occurred pursuant to an enactment of the state legislature in 1866. February 1866, the state legislature enacts a statute that creates
But isn't the question whether or not in the more recent past, a more current century, New York State has acted in a way that, as I think Judge Wilson is asking you, falls somewhere between that impliedly and expressly
Fair.
preempted.
2 points, and I apologize for building up this, but I buried the lead on it. And the point was that this isn't really a preemption question, it's an implied repeal question, and that's because the Board of Health is acting pursuant to an express legislative authorization. And there is abundant authority from this court, and I'd cite the case of Plunkett and Burke, which are cited in our briefs, and in a more recent second department case, Steinman, that says that when you have a special law, there is no concept of implied repeal by a later general law. And that makes perfect sense, is that when the legislature has called its attention to the needs of a particular locality, as it has here, and it has seen the board repeatedly exercise that granted authority, any step it takes that is general and statewide is not, without expressly saying, we want to repeal that prior special law, does not do so. And that's sufficient to resolve this question. If we move on to the second point, though, even if we put that to one side and treat it like a preemption question, this is quite short of what you see in other preemption cases from this court in a couple key respects. The first is, and this is the first point is less what the state has done, and more about the backdrop against which this occurs, is that here you do have this long history of action by the city in this area. You don't have that in these other preemption cases. It's not something that the state was unaware of. In fact, the state in 1966 acknowledged it. The State Board of Health in recent years has repeatedly said you need to go follow the additional requirements of the City Board of Health. It did that in 2010 regarding the number of doses for diphtheria. It did it again in 2015 when it enacted new vaccination rules. And in fact, the legislature in public
So
health
you're
law-
basically suggesting there's no way to see this as an implied preemption. So what would the state have to do for express? Just expressly say, we are now choosing to decide that the flu vaccine will not be mandated?
I think you'd also have to say, I mean, the state has never done even that.
No, that's what I'm asking.
I think in this instance, if we go back to the implied repeal point, what would really need to happen is to say we hereby repeal in part, in appropriate part, Administrative Code 17-109. But even if we put all that to one side.
Has to go that far? Can it not
That's
be
what you're-
targeted just to the flu vaccine?
That's what well, insofar as it pertains to flu vaccines. I mean, that would be the way it would be done. But even if we put all that to one side, what you see typically in an implied preemption case, and it's the DIAC case and many other cases, you see you may not see it in a statute where there is an express declaration that we hereby preempt local actions, but you usually see either in some declaration of policy or in some legislative material, whether it's a governor's statement, whether it's a legislative history of a bill, you see at least some indication that either there was an importance placed on a uniform state rule, either there were problems that had arisen, either the Consolidated Edison Red Hook case, which is relied on heavily by the petitioners. What the legislative record showed there is there were problems with uncoordinated local activity in the siting of electric generating plants. You ordinarily see that. You don't usually just see an enactment, a statutory enactment that establishes certain standards. You see something more. And if I could just spend just a second talking about what I think is probably the nub of this argument, if you get past all of these steps, this clause that was added in 2004 that says nothing in this subdivision shall authorize. Really, two key points to make about that. The first thing is that if you look at the bill jacket of that enactment, that was a purely status quo bill. The State Department of Health came to the legislature and said, we've reviewed our programs, we've been engaging in programs for adult immunization, we looked at the statute and we noticed we don't have explicit authorization for that. We would like you to authorize it. Codify something that we're already doing. And along with that, adult immunization. Along with that statute added that language, nothing in this subdivision shall authorize mandatory immunization. It was a status quo bill. It was not a bill. There's no indication in anything related to that bill that it meant to reach out and abrogate a separate authority that the New York City Board of Health had. And a second point, just a simple textual point about that clause, what it says is nothing in this subdivision authorizes mandatory immunization. It does not say there shall be no mandatory immunization. It does not say any other statute that purports to do so is hereby abrogated. We are not relying
So
on
you're saying we
that.
have to read it as it's just saying, we're not authorizing it. It doesn't matter if someone else has, or some other entity has. We're not going to authorize it. Is that what you're saying?
That's what it says. It says this subdivision does not authorize it. It does not purport to abrogate independent authorization.
And that doesn't reflect on some policy choice about whether or not any other entity could?
There's no indication that it does. And if you really look at the legislative history, it suggests that there was no reflection on that fact. And
Given under the city's choice, because it's the only choice I think it could make, that you're not mandating this for all children because they're not all in your facilities.
Right.
What is the administrative expertise that's deployed to decide that nevertheless that carries with it some health value, some health policy value, that we don't need to do everybody?
Right.
How do you get to that point? Because I know they raised that issue.
Can we, before you, see, that goes to, one of the things I've been concerned about is the Borealis analysis that's been used throughout the case, and it falls just to follow up on Judge Rivera's question on the opt-out policy and whether that undermines your claims in and of itself for the individuals that come in and you're allowed to opt out through a fine, whether or not that's an actual opt-out. And then secondly, applying it to only a percentage of the facilities and not to all the facilities seems to underline the public health basis of your analysis and undermines your program as far as any Borealian houses goes.
Well, I'll try to take those in order.
Yeah.
And the second one, obviously.
The red light's on. I wanted to get them up there. You can respond to me later on it if you can't get to them now.
I'm happy to take
It's up
them
to
now
the
because they
judge.
overlap with Judge
Please.
Rivera's
Please.
question. The so-called opt-out is a complete misnomer. It is not an opt-out. It is a mandatory rule, and any daycare that permits a child to attend after the date in the rule, December 31, who has not been vaccinated, will incur a fine of up to $2,000 for each day of that child's non-attendance. The first department, I do not understand how that.
You're basically just saying they were wrong on that point because in effect, it's not an opt-out because no one could financially afford it.
They were flatly wrong on that point. It is a mandatory rule, and even before that fine structure went into effect,
so go to the
there were
second-
already
go to the second
increasing
point.
levels of immunization. The second point, the essence of this point as it pertains to Boreali is, did you, and I think it was put quite well by Judge Kaye, as usual, in the Higgins case, she said, did you make an exception as an accommodation to special interests? Similar to the footnote in the NYC Clash case, the sugary drinks rule, a modification of the rule as an accommodation to the beverage industry. Don't interfere with the beverage industry. In Boreali, it was don't interfere with bars and conventions and political clubs. Those kinds of. What we're talking about here is just a recognition. Of a jurisdictional division that has occurred among daycare regulation for decades in the state of New York, which is that very small daycares, family and group family daycares are regulated by the state. Large congregate daycares, which are really what the rule what the rule focuses on, and rightly so, are regulated by the city. And this division of jurisdiction is not specific to the flu vaccine rule. If you look at that specific section of the code, it says nothing about it. It's just a result of the fact that the regulatory structure for daycares in the health code reflects that jurisdictional division among city and state law. And just parenthetically, the appellate division was wrong here too, really, when it said 20%. If you count by facilities, perhaps 20%, but the facilities regulated by the state are very, very small, and it is the bulk of children in daycare in New York, and the ones in the larger congregate centers, which are the hub of disease transmission, not just for these children that are at extreme high risk, but for their family.
Yeah, does that necessarily go to? I know the point you're making numerically. I understand it. I appreciate it. It's not that it's not compelling on some level, but aren't you missing a little bit of the argument that, of course, there is commercial value and pressure on having so many children have to be mandated to have this flu vaccine? I mean, somebody's making money off of it is the bottom line, just as they might have through some of these other choices. They may also have public health benefits,
Sure.
but there is a money part of it. So I'm not so sure I'm fully persuaded about your argument that there's no commercial pressure involved in this.
Well, but I think it's important under Boreali not to confuse every criticism or someone might or objection someone might craft about a regulation with what gives rise to separation of powers concerns under Boreali. And so when you talk about selectivity under Boreali, what you're really talking about is, I think, an agency that chooses to make an exemption from a rule, not because of, chooses to make an exemption for a rule, I think said well in Boreali, for purely social or economic reasons. I think theoretically a vaccine manufacturer, I guess, benefits to some degree from the sale of additional vaccines, but there's no reason why that consideration
Well,
raises
government
any
pays for
kind
them
of...
if someone can't afford them.
Yeah, government pays for
So
them.
that's a done deal, they're going to get paid.
They're going to get paid for them, right? The government does pay for them for people who can't afford them, and it's a good thing that it does. But nothing about that, when you come back to the core point of Boreali, is this a separation of powers problem? Have you jumped the rails off into something that's larger than you can do? The fact that you could find grounds to object to a reg, or even that you might think that a regulation may be less effective than another version of the regulation may be, is not a separation of powers issue.
Thank you,
Thank you.
counsel. Counsel?
Good afternoon, Your Honors. May it please the Court, Aaron Siri on behalf of respondents.
Counsel, isn't a flu directive precisely the kind of public health initiative you would expect of your Department of Health?
I could see absolutely that being part of what a Board of Health would consider, but they can only act in accordance with the policy that's been set by the legislature. And the policy here has been clearly set by the legislature in Sections 2164 and Section 613 of the Public Health Law. Section 2164 explicitly provides precisely which vaccines are required to attend school.
But for,
And no more?
I'm sorry?
And no more?
Well, if you read that in conjunction with Section 613 of the Public Health Law, okay? And I'll talk specifically about the flu shot for a moment rather than other vaccines, because I think it helps bring this into focus. In 2007, the CDC recommended that all preschoolers get the flu shot. That same year, the legislature down the block started debating a bill regarding the flu shot for school. After 4 years, in and out of committee 12 times, 7 times amended at least, and 5 times it was voted upon, at least by the Assembly and House, the end result was a bill that did what? It amended Section 613 of the Public Health Law to direct the State Health Commissioner, in participation with the New York City Board of Health, to encourage, to educate, to recommend the flu shot. But it did not include the flu shot, as it could have, under Section 2164 as a required vaccine. And what and where
How do you make
and here's
the
what's
jump
important.
to that?
I'm sorry.
How do you make the jump from that the city can't require it?
Right. So when the legislature passed that law, about encouraging and recommending the flu shot, where did they put it? They put it in Section 613. And what else does Section 613 of the Public Health Law provide? It provides nothing in this subdivision shall authorize, and appellant's counsel never finished the sentence, shall authorize mandatory immunization of adults or children, except as provided in Section 2164 and 2165.
But saying that nothing in that section authorizes it doesn't mean that something else
Right.
doesn't authorize it.
But what's in that section? In that section is the very directive to encourage, recommend the flu shot.
What I'm asking
And-
is, why can't we infer from what your accurate description of what the legislature did is the legislature decided it didn't want a statewide rule requiring flu shots, wanted a statewide rule encouraging flu education, and left the city with whatever authority it previously had, saying this section doesn't authorize anything new.
Yeah. I think that there's a field preemption, and I think there's also conflict preemption, and I'll try to say those very quickly. There's one other provision in Section 613 that helps support, I think, conflict preemption. In Section 613, it also says municipalities in the state shall maintain local programs of immunization to raise the immunity of the children and adults of each municipality to the highest reasonable level, and it requires that that plan by each municipality, including New York City, has to be approved by the commissioner. So here you have the legislature directing municipalities, including New York City, to create health, local vaccination programs. And what else does that section provide? It says nothing in the subject shall authorize you can't. We're not authorizing you. We're saying to you,
That section you just read says it has to be approved by the commissioner?
yes. So
And did the city submit a plan that includes flu shots, and was that approved by the commissioner?
I don't know, but I imagine whether they did or didn't change the requirement under the law. You know, there's one of the unique things about the public health law.
Wait, is that position that if indeed they submitted such a plan, the commissioner improved it, that the commissioner could not approve it, that would have been an abrogation or in violation of the law?
Well, I would say it's two things. I'd say, number one, the commissioner can't approve a plan that has that. And I would say, number two, even before they submit it to the commissioner, they're not allowed to make a plan that includes requiring the flu shot, because that very section that requires them to create local programs of immunization says that nothing in this section permits you to require any vaccines beyond 2164. I think the state legislature is clearly indicating what their intended policy
What's
is.
the adverse health consequences of the state, if we were to read it this way, saying, we're not going to mandate the flu shot. The city wants to do that, they can do so, but we don't see a need to do that. Is there an adverse health consequence for the state? The states have determined, we don't think there's an adverse health consequence, this is the way we're going to deal with the flu shot.
Are you asking me, is there a safety issue there? I'm sorry.
Well, I'm thinking of an adverse health consequence.
Okay, well,
We're talking about
I would
public
answer-
health issues.
I hope this answers your question. If it doesn't, please let me know. I think the answer, I think this addresses your question. When this court considered Boreali, it was well aware that secondhand smoke could cause lung cancer and kill people, right? Nonetheless, when it decided Boreali, it said the principle at issue had nothing to do with health. It has to do with separation of powers, whether or not the state health department had the authority to expand the locations at which smoking was not permitted. That's the only issue before I believe this court today, which is did the Department of the Board of Health have the authority to require the flu vaccine?
So 17, what is it, 109A or 107A? Doesn't that give the city express authority under the administrative code?
17-109
Yeah,
of
109,
the administrative code.
yes.
Yes, so 17109 provides a number of very specific powers to the Board of Health regarding vaccination, including collecting and preserving pure vaccine lymph and producing diphtheria toxin, and a number of others. Nowhere in any of the specific grants, when you read 17109, it's only 2 sentences long, nowhere in any of those does it say you can require a vaccine. Where appellant derives that.
But the city
Yeah.
has done so for
Right.
many, many decades, and never has, in anything that I've seen, has the state come out and indicated in any manner that it did not approve of that.
I'll take that in 2 pieces if I can, and hopefully I'll get to the second piece. The first part is that the authority that they derived, 17109 is from 100 years ago, and they derived, there is a general provision in there about controlling communicable disease, and it's from that general
I'm
provision.
sorry, I lost that last line. General provision on control.
Regarding controlling communicable disease.
Right.
So when you read
That's
7,
fine. Go
yeah,
ahead.
so when you read it, it says, it just has a general provision about
Right.
controlling. It's through that provision that I believe that the Board of Health has required vaccines in the past, okay? They haven't done so in almost 50 years at this point, of required a new vaccine. They've required some additional doses, required no new vaccine. And there are some principles of statutory, of legislative, statutory construction, I think, answer the question that you pose, which is later, more specific laws must yield to earlier general laws. They don't have to preempt them. We're not arguing that 1709 is repealed in any way.
But in
It's
2010 and 2015,
No,
the state legislature acknowledged and pointed to and recommended programs of immunization that the city was conducting.
I'm not aware of that being in the record. The only thing I'm aware of is the only thing I'm aware of is that there was the department, I believe what you're pointing to is.
Well, when they updated the regulations associated with 2164 of the public health law, I believe that there was some comment in.
Page 19 of the reply brief that was brought up. All right, so I didn't get a chance to address this because it was in the reply. But number one, that was part of the dicta to a regulation. It wasn't in the regulation, this language that opposing.
But that may all be true, but aren't we talking about here whether the legislature is aware of what the city is doing and has indicated its disapproval of same? And so whether, we're not talking about whether this is a controlling principle of law or not. We're talking about looking at the circumstances and whether there has been,
Yeah. The public health law is unique, I think, in the following way. Every single time the state legislature wants to exclude New York City from a provision of the it has done so explicitly. We've counted 209 specific sections in the public health law where where it says New York City is not included. But you know what's not excluded? It doesn't exclude New York City from section 613 of the public health law or 2164 of the public health law. It could have done that. It never did that. And 17-109, just to go back to your last point, it doesn't, we're not arguing that 17-109 is preempted, repealed in any way. It lives in harmony with the current statutory regime of the last 20, 30 years as codified in section 613 and 2164. There are general statutes that all the time must yield to later, more specific statutes, and it's a principle of statutory construction that whenever possible you try to read them in harmony. That general grant of authority regarding controlling communicable disease may have been used in the past by the Board of Health, unchallenged, to require certain vaccines more than 50 years ago. But in the last 30 years, the legislature has enacted a statutory regime that, number one, under 2064 makes clear precisely which vaccines are required, puts a regime that goes from beginning to end every single step along the way with regard to vaccinations and school requirements. And I notice my light is red, so I don't know if I can keep going, or should I?
You could finish your point.
Okay, and then under section 613, as I've pointed out, and so you've got under 2164, there is a field preemption because you have the legislature putting in a very detailed regime that goes from precisely, that applies to every state, it applies to every school, exactly which vaccines, what a school, parent, and local health official need to do if a child shows up without the required vaccines, what exemptions are permitted, what it is they have to do to get it, what appellate rights are permitted, all of those, and it's completely, so for that reason, we believe that there's field preemption. And then there's also field preemption because under section 613 of the public health law, when you read it, it creates a statewide program of immunization that is under the auspices of the state health commissioner. And part of that statewide health immunization program includes that municipalities in the state shall maintain local programs of immunization, requires them to. It's the same provision that specifically says encourage the flu shot, and it even includes the city as part of that program of encouragement, and then make sure to say nothing in here permits requiring any vaccine that we, the legislature, have not required under 2164. And, there's been a lot of debate about vaccinations, as I'm sure everybody in this court's aware. And, okay, thank you.
Thank you. Just to clarify a couple points about 17-109. The city, firstly, the key language is measures for general vaccination. It authorizes specifically measures for general vaccination. That has been in that statute from 1866 till the current day. 2 months after that statute was passed, it was passed in February 1866. 2 months later, the City Board of Health adopts a smallpox vaccination mandate. And in the volume that collects that mandate, it says in the margin, Health Bill Section 16 as the authorizing section, and that is this precise language. By the way, the Jacobson case, the big Supreme Court case on vaccine mandates uses general vaccination. The attorney in that case used that phrase. The Attorney General of the State of New York in a 1903 opinion we cite uses that phrase. And as your honors have pointed out, we have consistently adopted vaccine requirements pursuant to that language. And this idea that we haven't adopted any in 50 years, also untrue. The state did not catch up to the city until 2004 when the state finally added pertussis and tetanus to the Public Health Law 2164, which had been in the city law for quite some time. So the city required additional vaccines from going back to 1866 through 2004. Even from 2004 forward, it required additional doses of the DPT vaccine up until 2014 when the state caught up. And the DOH consistently referred to the city's additional requirements. And then in 2013, we passed this flu vaccine rule. So really, you're saying 1866 to the present day, the city has required additional vaccines.
Do you know the answer to my question about the submission of a plan to the commissioner?
I do not, Your Honor, and I can certainly find out that answer and give it to you. I don't think it affects the resolution of this case. And the reason is that whole section is about state aid. That's the label of the article and the title on the section. And so what it says when he's referring to approval of the commission, approval of the state commissioner, it's not in the abstract, it's in connection with an application for state aid. And so the reality is the local boards of health, local departments of health across the state do many things that are not funded by state aid. The city board of health in particular, and this New York City actually applies directly to the Centers for Disease Control for direct funding that covers the city of New York. The State Department of Health applies to the CDC for funding that covers the rest of the state. So those two things really don't have anything to do with what we're talking about. And as I said, the language, that language at the end, it says nothing authorizes it. Nothing in this section authorizes mandatory vaccination, and we're not claiming that it does. There's no conflict there. Just one last point about the statewide coalition case to try to add a little. You invited me to answer your question on rebuttal, and I'm going to take you up on it, which I should have mentioned earlier, is that there's a footnote on this issue of coverage, which facilities does it apply to and which does it not. In statewide coalition, there was a similar issue because the city board of health rules about food service establishments applied to certain kinds of establishments and not others, basically restaurants but not grocery stores or bodegas. And that was an issue in the case, and this court, although striking down the rule, dropped a footnote that specifically said that fact alone would not cause a problem under Boreali. It's really analogous to what's going on here, and this court has really already held that's not a Boreali issue. If I could just make 20 seconds for one last point.
May.
This reliance on the so-called unenacted bills or the fact that a bill gets amended or how many times does the bill get amended, I'm not aware that the bill he's referring to that ended up with the education program ever included a flu vaccine mandate. I don't believe it ever did. It was amended in technical ways, eventually passed. On the idea that bills are introduced, there are 12,000 bills introduced in the New York State Legislature every year, at least by a factor of 2, more than any other legislature in the country. Only a small fraction. We're in the bottom quintile, actually, as to bills passed. The fact that a bill gets introduced, merely gets introduced, means nothing.
Thank you,
Thank you, Your
Counsel.
Honor.